Okay, story time. This is a real matter that we resolved just a couple of weeks ago, and it's a roller coaster. Going back in time, so the client moved to Australia in COVID because he had to leave Singapore very suddenly. He was then stuck in Australia for well over a couple of years, and at some point he became an Australian tax resident. Trouble is, he was on a pretty excellent salary in his job in Singapore, and therefore, when he became an Aussie tax resident, his tax rate jumped significantly. In that first year in 2020, when he was here and he was trying to leave consistently, try and get out, but obviously he couldn't, flights were essentially impossible to book, he became a tax resident. And what happened is there was an initial ruling lodged, not by us, but by the accountant, saying, when is he a resident? And the ATO said he's a resident on 1 July. Now, that's a bit of a problem because from 1 July, that's when he's paying that higher tax amount. We looked at the set of facts and we said, we can do better. So we did something a little bit unusual in that we lodged a second private ruling on the same topic. The reason that's a bit unusual is normally you would object to a ruling that you don't like. But we thought, well, going to objections, we're going to get someone probably not a specialist in tax residency. But if we do another ruling request and the ATO accepts it, then we'll get someone who's more technical from the technical area of the tax office. ATO could have declined it. They could have said, we've already ruled on this matter, that's it. But they did actually accept it. It took quite a long time to just get through this whole process. It took about 10 months in total, but we lodged it and it got allocated and they actually considered it, which was already a win. The first ruling was quite small. It was 3, 4, 5 pages. Our ruling request was, I think, 61 pages. And it came with like comprehensive timelines and reasoning about why it was X date, not 1 July. Because there was no actual reason why it was 1 July. It's just a convenient date to pick so people don't have to do part year tax returns, but there was no actual facts to support that's when this person became a tax resident. So after 10 months of lodging the thing and 3 or 4 information requests from the ATO, which we answered, we finally got the outcome and it was positive. Tax residency didn't start until 7 months after 1 July, so in January the following year. Saving this dude quite a bit of money, but also pushing back on the ATO when there was, first of all, value to get, and there was actually no reason for that original decision. So it was worth challenging. It was essentially a risk-reward thing, and the risk being that the client has to pay some legal fees, obviously, and the reward being more than the legal fees were worth. And that's why tax lawyers are a good investment.